With advances in technology, people are enabled more now than ever in history to write and record music, their own original music and the music of others. But it is important to understand that there are a lot of U.S. laws and even international laws that may apply to the whole process of creating, writing, recording, and exploiting musical works. A piece of recorded music basically has two parts. The first part is its underlying musical composition, that is, its lyrics or words, and its melody or notes. The second part is the sound recording, or sometimes called the master, that captures the performance of that underlying musical composition. Likewise, potentially at least two copyrights apply for any piece of recorded music. One set of copyrights related to the musical composition and another set of copyrights related to the sound recording. Under United States copyright laws, owners of musical compositions and recorded works have the exclusive rights for a period of time to control what happens with those works. Of course, permitting or licensing others to use their works are the means by which copyright owners make money. In 2018 in the United States, it is estimated that annual U.S. music publishing revenues hit $3.3 billion. In that same year, revenues from recorded music reached $9.8 billion at estimated retail value. So, who are the owners of such musical compositions and sound recordings? Under United States copyright laws, owners of a work's copyright will either be the initial author of the work, an employer of a work's initial author, a copyright purchaser, or a mixture of such parties. But what happens if there is more than one author of a musical composition, known as a co-written piece of music? Well, under United States copyright laws, unless there is a contract or writing that states otherwise, a musical composition is owned equally by each author based on the number of authors. So, if a musical composition has 3 authors, then each author owns a 1/3 share of that musical composition. In the context of a band, it is very common to have multiple songwriters that contribute different amounts of authorship to a single song. Again, unless there is a writing, such as a contract, in place to explain who authored and owns which parts of which songs, misunderstandings can develop concerning related revenue splits, control of the music, and ownership of the music. It is therefore almost always a great idea to have a co-authorship or collaboration agreement in place between co-writers of musical compositions. It can also be important for many reasons for a band to have controlling documents in place to guide a band's business and legal affairs. Such documents often take the form of collaboration agreements, licenses, license-back agreements, a pooled royalty split agreement, and corporate structuring paperwork such as an operating agreement and a shareholders agreement for the band's limited liability company. Of course, owners of copyright are not just limited to licensing their works. They can also sell or transfer their copyright ownership interest by assignments, which under United States copyright laws must be in writing in order to be valid. For example, a songwriter might assign all or a part of their ownership interest in a musical composition to a music publisher. The music publisher then pays the songwriter for those rights and then goes about licensing their assigned rights to make a profit. Another example is where a record label might hire a record producer as an independent contractor to make sound recordings of a musical group performing musical compositions. Normally, the record producer and musical group would assign their copyrights to that record label. That label then would work to exploit those copyrights for profit by selling copies of the sound recordings, whether by digital download, CDs, or even vinyl record sales. Lastly, it's important to know that in the United States, a work is under copyright protection the moment it is created and fixed in a tangible form that is perceptible either directly or with the aid of a machine or device. That means, for example, that a lyric for a musical composition is normally protected the instant it is written on a piece of paper or saved as a digital file. In the United States, a work does not have to be registered with the Copyright Office in order to have protection. However, registration is recommended for a number of reasons. Many choose to register their works with the Copyright Office because they wish to have the facts of their copyright on the public record and have a certificate of registration. And only registered works may be eligible for statutory damages and attorney's fees in successful litigation. There are other important reasons to properly register works with the United States Copyright Office. The Copyright Office has a lot of great information concerning copyrights and copyright protection available for viewing and download at www.copyright.gov. Go check it out.